Put the glasses on, make us look smart.
Yeah.
Welcome back. I'm Bryan. This is my partner, Joe. We're attorneys from the Trenti law firm. We've embarked on this podcast journey, partly to spread information and try and help inform the public, partly to entertain, partly to be cooler with our kids. I think it's working so far. I don't think we're not professionals yet, but we've got a topic this week, and we're a little bit more focused than we were originally. So welcome back, Joe.
Welcome back, Bryan. We should give ourselves a name. Range Lawyers or... we'll think of one by the end of the
We'll come up with something
series.
that reassures everybody this is non-billable.
Oh, okay, what are we going to talk about today? We know what we're going to talk about because we discussed it.
Because we're organized and we're ready to go this time. Products or premise liability.
There you go.
But
We
products
got it.
liability is good.
That's going to be the next one.
All right.
We can talk about that.
Premise liability.
There's a lot to talk about premise liability.
Well, just kind of a large overview. Premise liability, we're normally talking about negligence case. Would you agree?
Yes.
All right. And negligence cases, easiest case in the world, right, Joe? 3 elements, a duty, a breach, and a damage. I think we're done. It was a great episode this week. No, but in all seriousness, that is the foundation of most premise liability cases is a claim of negligence. And while negligence is something that's easily stated, it is a negligence case and its elements in the legal form is that there exists a duty that somebody owes to another person, that they've breached that duty, they haven't followed through with what they're supposed to do, and then as a proximate cause of that breach, somebody's damaged. But in those 3 simple things, there's a lot more.
A lot more. And today we're going to try to educate someone that has been injured and also the property owner to things you can do to prevent being sued and things that you do that will get you sued. So we're kind of approaching it from both ends. We're going to talk a little bit about insurance. We're going to talk about some business. We're going to talk about your home, your hunting property, your cabin. If you own 40 acres where you go four-wheeling and there may be a snowmobile trail that goes through it or near it. If you have property by a park and there's kids around, they get on your property, dog bites. We have a lot to talk about. So pay attention.
Premise liability in its broadest sense just means that somebody was injured and that injury arises out of a duty of a landowner that they owe to either somebody who's invited onto their property or somebody that they reasonably should foresee is on their property, or in some silly cases that you'll hear about as we move on here. Sometimes you owe a duty to people who shouldn't be on your property, which gets a little bit more interesting. But Joe, home, business, recreational property, where do you want to start?
Let's start with the home.
All right. So in your home, what is the best way to characterize the duty that a homeowner owes to a guest or an invitee?
You got to make your property safe, period. In the wintertime, you got to shovel your walks. If you don't, you're liable. Someone slips and falls, that's your responsibility. The only time that you're probably not responsible is your neighbor comes over for coffee. It looks like it's going to rain, but it's cold, and you're having coffee, and no one realizes that it's rained and ice has formed, and the neighbor leaves, and you had no knowledge that there's going to be ice on the sidewalk, and the neighbor slips and injures themselves. That neighbor would not have a claim, but your homeowner's insurance would end up paying their medical bills on what's called a med pay, meaning, sure, they were injured on your property, but you weren't at fault, but let's compensate people for their medical bills, which is a good insurance policy. It's responsibility taken to its fullest. So we'll start at the home.
So historically speaking, prior to the 1970s, the duty that was owed by a homeowner to a guest or we call them invitees, but it's your friends. It's the people you invite to your house. The duty that was owed was a pretty minimal duty. That changed in about 1972 with a case that involved a slip and fall on ice. That case, ultimately, what it held was, the duty that's owed by a homeowner is similar to the duty that other landowners own. If you invite somebody onto your property, you have to act reasonably and exercise due care to make sure that they're not going to be injured. Now, that doesn't mean that you've got to wrap your guests in bubble wrap or wrap your property in bubble wrap. What it really is saying is that you can't maintain a condition that it's foreseeable will cause somebody harm, and you can't create dangerous conditions. So we don't get any cases like that, do we, Joe?
So the easy one is the sidewalk case, which we've talked about. You have to maintain your sidewalk. We'll get into if you're a landlord tenant or business owner and so forth. We'll get into that in a minute. But the other thing, as a homeowner, you have to keep your property safe. Meaning, if people are going to be walking around your property, you have to know where there's holes are. You got to plug those holes. You remove the plant and you got a big hole there. And you think to yourself, well, everyone will see it. Well, everyone doesn't see it. It's called open and obvious, and it's a defense. But you, as a homeowner, knew it was there. You knew someone could fall in there. You knew someone could. They should have seen it, but you knew maybe they didn't see it. And if that person walks, steps in there, falls, breaks their leg, gets injured, you're responsible.
Yeah, it's a good way to think about it. And I don't know how correct this is, but there was a comedian who once said, imagine how stupid or foolish the average person is, and half of them are worse than that. So when you're looking at liability at your home, it's just good to keep your eyes open to those things. Is there an awkward step into your entryway or your threshold of your home? Is there a loose or rotted board on a deck or a platform that people would be walking across? And in those cases, the law a lot of times would say, well, if you knew about it, you would know that a loose or decayed board on your deck would cause somebody to fall through and get injured. And in those cases, it's going to be pretty obvious.
An old lawyer once told me, insure your property, protect your property, like you invited 10 drunk people onto your property and you know that they're going to fall or get hurt, and you've got to prevent that. That's stretching it, but it kind of sets up the scenario that you are, as a homeowner, responsible.
And just for fun, invite 10 drunk people to your house and test it out. See how safe you are. So, Joe, I can take a couple of easy ones. We've got a Minnesota statute out there. It's 609.66, and in subdivision 1...
He's the brain. He knows the statute number.
Parens A, parens 4, it's very clear that you're not allowed to set spring guns, which are those old... It was an old booby trap that people would set where you open the door and the shotgun blasts toward the door. Can't do that anymore. No pitfall traps, deadfall traps, no snares intended to catch humans. You can do snaring. You got to talk to the DNR about that. No human snaring or anything like that. So it's a statute that says we can't set booby traps anymore.
And what about, since we're on guns and so forth, can you have a gun, a knife, a weapon to protect yourself in your home or outside your home? Let's talk about...
We're opening up about 3 episodes worth of material here.
Should we bypass it? Or
No. So there's a simple answer, and the answer is yes. But the case law is very clear in Minnesota. Minnesota's not what we call a castle doctrine state.
Or defend, you can defend your property state. Or...
Well, you can, but a castle doctrine state is a specific kind of a state. It's a specific doctrine. Basically, it says if somebody comes into your home, you automatically have a right to defend your home, and you don't have to retreat from your home. Now, Minnesota's not quite that far. Minnesota actually has, our self-defense case law is pretty clear. You can't use lethal force, so you can't use a gun or shoot a gun or throw a knife point end forward or handle forward at an intruder if all you're doing is protecting personal property. But if you're in reasonable fear of great bodily harm or death in your home, you're still authorized to defend yourself.
And there's a theory, I don't know if there's a case, you probably would know it, that if you, as a homeowner, have an opportunity to escape, you have to do that. So say there's an intruder and you have a gun and you say, get out, I have a gun, and he's still coming, but you don't know where he's at. And if you can exit a back door, I would err on caution. I'd get out that back door and hopefully had a cell phone and call the police. And if he still came after you, then you have to do what you have to do.
You've at least got to ask yourself very seriously, how much spare time do I have and how much paperwork do I want to do?
And I just renewed my gun safety class, and the instructor, he repeated himself about 20 times that you can use a weapon in self-defense if you believe there's going to be great bodily harm to you or another. But expect to go to criminal court or at least to be questioned by the police and all the aspects and all the facts of that shooting. Because you can't just say, he was coming at me and I just shot him. There's going to be an investigation.
And then call Joe or I.
All right, we kind of got deep there.
No, I think that's a good segue, a good aside. But no spring guns. That's the moral of the story. No, if it is self-defense, it's got to be actually person to person. You can't set a trap to do it. Those are the easy ones. Slip and fall cases more difficult a little bit because there's open and obvious defense, which basically, if we're summarizing it very clearly, but open and obvious says if it's something that everybody should see and you should avoid it because you could get hurt, you have an obligation to try to avoid it and to mitigate your damage and not intentionally put yourself in danger. But when you talk about those sorts of things, if you're talking about those sorts of things, you've probably gotten past what Joe and I are trying to give to you today, and you've put yourself into a situation where at least there's an arguable claim and you're in litigation, you're dealing with guys like us or worse defense attorneys, and you're already down that road. So just be careful and think about the 10 drunk guys that you're going to invite to your house. So
let's talk about the landlord-tenant and the responsibility of the tenant and the landlord. We've had cases where the tenant is moving in or moving out of an apartment and they trip on the stairs and they fall and are seriously injured, or their guest or helper, falls while lifting furniture on the stairway. So you have to examine the facts. If in fact there was a nail that was sticking up that the landlord is going to claim, oh, you should have seen that, it's been there forever, you lived in that apartment for 3 years, you knew it was there, it's open and obvious, like Bryan said. Well, maybe not. The landlord has that responsibility. The landlord should have seen that nail sticking up. Sure, the tenant was there for 3 years and saw it and didn't say anything, but the tenant's cousin who's helping him move, he didn't know it was there. And so the landlord has that responsibility.
Yeah. So that a part of the difference, and we divide these out into categories about different types of premises. So Joe and I talked about the home already. Now we're talking about landlord-tenant. It's a slightly different category because it presents slightly different facts, and there's an additional layer of law that goes along with it. Ready for a smart one, Joe? Minnesota statute 504B et sequium, which means all of the provisions of that
Can
general
you spell
section.
that?
No, but I know it's in italics.
We got to have spell right or whatever it's called.
Can I call my paralegal?
Yeah, get a call a friend.
So, but that 504B section of the Minnesota statute deals with the relationship between landlord and tenant, and that creates some additional responsibilities that can form the basis for premise liability. Because the landlord is required in certain sections to perform certain levels of maintenance to make sure that it's a safe and livable condition, that it's fit for the intended use, which is a residential dwelling. So because there's that additional layer of law on top of it, it changes the analysis slightly. So when Joe and I were talking before, you get the classic case of an icy sidewalk outside of your home. In the landlord-tenant situation, the analysis of that same icy sidewalk could be a little bit different because your lease may dictate who's responsible for clearing that ice and snow. Maybe it's the tenant's responsibility. So if it's an icy sidewalk and I'm the tenant and it's my responsibility, it may change the liability slightly if I go slip on an unkept sidewalk and it was my responsibility, where if the lease places it squarely within the landlord's responsibility, then we're looking at a different kind of case. So that's why we talk about these as slightly different variations on that homeowner theme.
And every fact is different. We had a case where a lady was going to see a business owner. I'll call it a chiropractor. It wasn't. And she slipped and fell on this one piece of ice, this black ice. She didn't see it. Well, and she was hurt significantly. And so, we got the lease contract, and the business owner was supposed to have shoveled it and maintained it and make sure ice wasn't there. Well, we contacted the business owner and their insurance company, and the business owner said, I try to keep it clean, but this roof where it's at, it leaks constantly, especially in the springtime, and I get an overabundant amount of water, some snow in that area, and I can't be out there every minute doing this, and the landlord has responsibility. And we settled it, and both the landlord and the tenant shared in the responsibility. So it's always not black and white.
Yeah. It kind of raises an overarching theme through all the premise liability. One of the questions that always comes up during premise liability litigation, did you know about it?
Yeah.
Should you have known about it?
Could
you have known about it?
Yeah.
So always keep those things in mind. The example with the business owner and the sidewalk, the fact that business owner came out and said that it always leaks right here, there's always a spot of ice here, that proves that he knew about it.
And part of the story I didn't tell you. Here's the rest of the story.
Hey, it's Paul Harvey.
Yeah, it's the tenant had complained numerous times to the landlord, and the landlord didn't correct it. So yes, you got to get into the facts, and you as the injured person, you don't have and you don't want that responsibility or the capability. You hire the lawyer, we do the work, and we protect your interests.
Yeah. Going back to the landlord-tenant area, within the residential unit, so within your apartment, if you're a renter, you as the tenant in the apartment owe duties to the people that you invite into your apartment, much like a homeowner would owe to somebody that they invited into their home. But on top of that, the landlord owes a general duty, more specifically in the common areas, but a landlord also can't allow a dangerous condition to exist within an apartment. An interesting case maybe, and I haven't had this case, and I guess I haven't looked to see if it's out there, if someone were injured in a fire in an apartment, and both the landlord and the tenant was aware that there was no smoke detector that could have provided warning, and a third-party invited guest was the injured person in that fire. Joe, what do you think?
Well, that's where you probably would point to both of them. One, the tenant should have had a working fire alarm in the apartment or in the rental home. And secondly, if there's common areas, the landlord should have had a fire alarm that would have and should have been heard by all the tenants. And common areas are hallways, entranceways, if you have a community guest room,
Parking lots.
So yeah, it's our job is to find as much insurance as we possibly can, and we do it. And so if we think the landlord's at fault, we'll sue the landlord. If the tenant's at fault, we'll sue the tenant. So everybody has a responsibility. Everybody has a stake in the game here, really.
And sometimes the duties and sometimes the breaches aren't as clear as a rusty nail sticking up or an icy sidewalk. There's case law that exists out there. It's older case law now because you don't see a lot of these buildings, but there was an apartment complex, a residential apartment complex that was in a high crime area. And the apartment complex was a nicer complex, and they were finding that the tenants were more and more becoming victims of robberies and assaults and things like that. And in response to all of this and the increased cost of operation, management for the apartment building reduced the amount of security, live security that they had in the building. As you would expect, somebody got robbed in the hallway of the building, sued the landlord, and they actually prevailed. The court in that case found that if you know that this crime is a risk and you had security put in place to try to prevent that harm, and you reduce that security or you reduce that expectation that people have had about what protections they're offered, and you don't give notice and you don't supplement it with some other kind of protection, you could be liable for that.
Yeah, and the parking lot cases, we've all read about them, where someone was significantly injured, raped, killed, beaten, and the owner of the parking lot should have realized that that was a vulnerable spot. There was no light. There was no area where someone could scream, and it was just a bad area. And if you own a parking lot, you got to inspect it, and you should know that. Yeah. So,
and that actually raises some interesting questions. If you have security, if people expect that they're protected in a certain way and they're not, there's a fairly common security technique where you put up a dummy camera or a fake camera to protect people. And if people come in and look around and see those cameras and say, I'm in a place that's monitored right now, I should be a little bit safer, but they're not, and they come looking for that footage, potentially some liability. Would you agree, Joe?
oh, absolutely.
And even worse case, if there is an actual camera and that camera is a real camera and it's broken, and the property owner doesn't remove it or doesn't take some reasonable steps to repair it, also I think there could be some liability that could attach.
Yep.
So the question you may run into there would be causation. Would the camera have prevented the harm? Maybe not, but it would definitely help you recover.
Yeah.
So
Exactly. What other areas? Get my glasses on.
businesses?
Businesses, yeah. You kind of covered that, but what were you thinking?
Business, so the duty that is owed by a business sometimes in the law is viewed as a little bit higher as I've run into it. And the reason is because you don't just have invitees. If somebody's coming over to my home, like, hey, Joe, you want to come over for dinner? Joe would say, yeah, or he'd say no, or, but we're inviting him over because of our personal relationship. Businesses sometimes are held to a little bit higher standard, or the rules are enforced a little bit differently or more stringently to businesses, because they're not just inviting you in as a friend. When you go down to your big box stores, or you go down to even your local grocery stores, you're not going in as their buddy. You're going in to pay them money so that they can continue to make money and profits and pay their employees. And they have staff members that in most big box stores are continually moving around. So their ability to know of and be aware of spills, dangerous conditions, broken glass in the aisles, those sorts of things is a little bit higher than it may be in a personal residence or even in an apartment complex.
And every box store, even the smaller stores now, have cameras that cover every inch of that store. We've been in claims against the box stores, and if in fact the camera shows they're at fault, you have to start the lawsuit to get the camera or to get the video. If in fact it shows that the person caused their own injury, that box store will give that video up in a minute.
They'll mail it faster than that perfume letter I referred to in our pilot episode.
But here's back to a slip and fall in a business. So the business owner, it's icy that day and they don't get out to clear the ice, but you as a buyer, you walk and you see this patch of ice and you say, well, I'm going to, I'm just going to walk across it. It's their fault. No, that's open and obvious. And there's case law that says you have the responsibility. If you see it, you have to avoid it. Now, if you see it and you want to get into that store and you take a different path, and that different path has some dangers, well, you can bring a suit. We've had claims where there is icy conditions and the box store will say, well, it's open and obvious. And the client will say, it wasn't. It was covered with snow. I can walk on snow. I don't, walk on snow all the time. It's not dangerous. But if there's ice underneath that little bit of snow, yeah, it's dangerous. And the box store is responsible. So
other kind of common things, common issues that you can run into, premises liability things that you find more often in businesses and commercial settings, the way things are stacked on shelves. If they're putting things that are unreasonably heavy up on higher shelves with the reasonable expectation or foreseeability that even though they may say team lift, they know the average person, especially younger guys, aren't going to team lift. They're going to try and pull it down and carry it off. those things can create liability.
Yeah.
There's just so many different, I mean, if you can imagine a scenario, there's probably a case out there or could be a case out there that talks about it.
Yep.
So,
All right, let's move on to the next one. We want to talk about dog bites?
I think we do. Dog bites are a part of premises liability, especially as it relates to your home, because that's a lot of times where you're.
And it's not only dog bites, it's dog intrusions, dog being dogs and pushing you over, and we'll get into that, but it's a significant responsibility. We all have them, we all love them.
Is there a simple rule out there about dog bites, Joe?
Yeah. The homeowner is liable unless the dog was provoked. What does being provoked mean? Well, when you've got the 6-year-old kid pulling the dog's ear, pulling the dog's tail, and no one says anything, and the dog turns around and bites them, that's a defense. It's not an automatic defense, but, and unfortunately the child gets bit and hurt. The insurance company for the homeowner will raise that as a defense that the young lad provoked them. Rarely does that happen. You hear it all the time. I've heard it today even. My dog would never bite anybody. If I had $1 for every time I heard that one, and their dog did bite somebody.
There's a great case out there, Joe. There's a dog bite case out there where the dog clearly was an aggressive type of dog, and the owner of the dog was talking with an acquaintance, and the acquaintance said something about the dog looking kind of mean, and the owner of the dog said sarcastically, "Oh, this dog would never bite anybody." The guy reaches down and gets bit. That plaintiff in the case, the individual who was bit by the dog, recovered both on strict liability for the dog bite and fraudulent misrepresentation.
Yeah, and we've had cases like that. The young man's walking down the street and the family's out having a barbecue and nice looking dog and nice dog. Oh yeah, want to pet him? Sure. Walks up, exactly that. Boom, the dog bites him. Oh, my dog never bites anybody, but you hope it never happens. I mean, the dog bites, you get bit by a dog on the leg or the arm if you're an adult, well, you got a claim, but you're going to live through it. But we've had
Kids. It's always the kids.
Just get bit in the face.
Yeah.
So, bottom line is, if you own a dog, you have a lot of responsibility.
And if you own a dog that's bit once before, it's an extra responsibility. In those cases, there's most cities, and I can tell you almost every city locally has an ordinance in place, and there's a state statute on dangerous dogs. The additional responsibilities, once there's a bite incident that occurs, there are additional responsibilities. We won't get into those here, but it's always good to kind of know the history or know the temperaments of the dogs in your neighborhood if you're going to be out walking or if you're going to come in contact with them.
Yeah, and the homeowner, beware, if you have a dog, your insurance, make sure you talk to your insurance agent. There's certain dogs that they won't insure, or they will restrict the insurance. So say the typical homeowner has a $300,000 liability coverage, meaning that if someone's injured and if the homeowner's at fault, the insurance company will pay up to $300,000 for that injury. Well, there are certain clauses in certain insurance with certain insurance companies that say that they'll only pay up to $25,000. And in our experience, if you get bit by a dog and it's not on the ankle or not on the arm, if it's somewhere else on the body, that claim is well over $25,000, well over it. And you as a homeowner are out-of-pocket responsible. Be careful. Read your policy, talk to your agent, and they better tell you up front what it is. So you're insured properly, yeah.
In a beware of dog sign, it's good, but not great. As a homeowner, as somebody who's got a responsibility for a dog, a pet, putting up a sign is good. It goes to a mitigation or an assumption of the risk argument, but that sign isn't going to do you much good if you put up a sign and then invite somebody into your yard. Yeah. Just having a beware of dog sign may protect you in a case where I'm walking down the street, I see a beware of dog sign, I think, hey, I love dogs. I'm aware of it now, so I'm sticking my hand through the fence to try to pet it.
Yep.
It may protect you there, but putting up a beware of dog sign and then inviting somebody in, or putting up a beware of dog sign when you know the mailman's got to deliver through the area where the dog is loose, all of those things are still going to expose you to liability. So just putting up the sign is a good start, but it's not going to...
We've been asked, should we put up a sign?
That's a good question.
Are we inviting, I've got a dangerous dog, the mailman has to come there,
Am I admitting that something's going to happen?
Yeah. It all depends on the facts. There's no...
And it depends, I think a good amount of those facts are what else did you do?
Yeah.
If all you do is put up a sign and you let the dog roam freely and don't put up a fence, you put up just a single metal post in the front of your yard, beware a dog, and then you let the dog run loose, that sign's going to hurt you. It's you saying, I have a dog that's dangerous and good luck. But if you couple that sign with taking additional precautions, you muzzle the dog, you keep the dog tied up, you put up a big fence, you keep people out, you don't invite people into your yard, you make a safe path for the mailman to travel. In combination, all of those things make it look like you're a lot more reasonable. Then the question becomes, well, you knew there was a dangerous dog. How did you get to it to get bit? So...
Yeah, and the scariest thing is the person that puts up the chain link fence and they have the dog that runs up and down barking at people, walking on the sidewalk. Eventually that dog's going to jump that fence and cause injury, and I don't care how many signs you have up, you're liable.
I think we should start putting up beware cat signs. Cats are mean on purpose.
When people ask about insurance companies, well, we're not in that position. They're all different. Insurance companies go with the responsibility that at the time, like if they had a big hurricane down in the southern states, they're going to hold their money tight, and they're going to it's like a pendulum. They make you go to trial in many of the cases. Things are good, they like to settle them. And so we can't discuss what's good or bad. We both have different insurance companies. So, shop, do your best, and make sure you know what's in your policy.
Get to know your agent, make sure you're comfortable with the folks that are selling you the insurance, and ask questions. Ask questions about your coverage, ask questions about how they approach claims. It can help. But ultimately, my experience, Joe, and maybe yours may be a little bit different, my experience is by the time we get into the situation where Joe or I would be involved as a plaintiff's attorney, there's been a harm and we're trying to help you recover. You're typically not dealing with your local folks. They're hiring outside adjusters and folks that aren't from our communities. And, then it all becomes a corporate office, and it's the work to try to make sure that and that's a big part of what Joe and I do, is just make sure that our clients are treated fairly and compensated the way that they deserve to be for the injury and the harm that they've suffered.
Yeah. Well, we've thrown a lot of fear into homeowners, landlords, tenants, but we all are one of them.
Well, you got to ask the question, Joe, what could go wrong?
Exactly.
But I've mentioned this before, and I think it's worth mentioning again. A lot of what we're talking about doesn't happen in day-to-day life, but it's important because it can happen in day-to-day life. It can happen anytime. I could be walking on my way home and fall on the sidewalk, and we could have issues or questions with the city about how did you maintain your sidewalk? Maybe we should talk a little bit about those cases, Joe. Sidewalks and government action in
That's another day.
In premise liability.
That's another day. But in all these cases, it's fact driven. What are the facts? And we have investigators to go out and to investigate the facts, to get the information. It's not like a car accident where the police do a lot of the work. The police are there, they get the information, people tell the truth right after the accident, more so than 6 months later. But, on the dog bite, there may not be a witness. At the slip and fall, there may not be a camera. There may not be a witness. And so we got to get someone out there to take photos, to kind of just walk around the property, to get a feel for the property. And that's what we do. We have those people. We have the knowledge. Bryan has the specific statutes in his head I go by experience.
And maybe that's another pro tip that we can give is if you're in a situation like that, if you suffer a fall at a commercial business, if you're injured while visiting, you hate to say it, injured visiting a friend or visiting another home, just document it. It may be nothing. Yeah. It may be something. There's soft tissue injuries. There's some injuries that something will happen and it doesn't become really apparent that something's wrong for a period of time. So it's good to document those things. When you're involved in a serious incident, you fall and break your leg on a spot of ice that everybody knows is there at a business. Document everything that you remember after that happens, and then keep a journal of how did that fall, how did that injury affect you over time.
Yeah, and
those things are important.
That's a great subject, and that's another whole podcast on injuries and treatments and care and expenses, and so we'll save that one for another day, and it's about time to wrap her up. And
I may close with this, Joe. We're not gonna get too far into municipal liability or anything like that. But if you're ever walking downtown and you see on the sidewalk there's a chip or an uneven portion, and you see it painted orange or painted a bright color, that wasn't Joe and I that went down and personally painted that. But we like to believe that we play a small role in making sure that all of those things get painted, and that's a fun or whimsical way of saying a good part of what Joe and I are intending to do by the professional work that we do, is to, number one, help people who are injured recover reasonable amounts to compensate them for the injury and the harm, the pain, the suffering, the damage that they've incurred.
Yeah.
But the other aspect of what we do is personal injury attorneys at their core are trying to make things better. We're trying to make things safer. It's apparent there's large lobbies of plaintiffs' attorneys, even though it's contrary to their interests. There's large lobbies of plaintiffs' attorneys that organize nationwide to advocate for better safety, especially in the trucking context, commercial vehicles. Those groups are instrumental in trying to create rules and promote standards that make more safety on the road. I don't think Joe or I would complain if the world became absolutely safe and we had to find a different kind of law to practice and hassle people a different way and bill hourly. So that it's an important part of what we do. And all joking aside, a lot of what we do is try to make things safer and better for people. With that, I think we've probably gone on long enough.
Yep.
We will regroup with another topic, and we'll be back before too long.
And maybe we'll have a name for ourselves other than Bryan and Joe.
If you have any suggestions, please send them down.
And give us a call, send us an email. We have our website, Trenti Law.
Okay.
And we'll be more than happy to call you back, or we'll answer your questions on the next podcast.
And as always, if there's topics or subjects that you'd like to hear about, let us know what they are.